notify for travel. I'm sorry, he had to notify for travel for personal reasons, but he was free to travel anywhere for business travel. Judge Giles modified that and required, I think, a 48-hour notification to the court for business travel only. And I think
to the court, to the prosecutor, to pretrial services, to the court.
To the court, yes. And I think the reason that was put into place was to guarantee the confidentiality if there was a business travel that no one, that the mayor of the city should not let other people know about. So that was the requirement. All I had to do was make a phone call 40 hours to going out of the country. That was a modification in May 20th, I believe, of this year when the court issued that order. But it's not just about the trip to Canada on the 23rd of July that got the defendant's bond canceled and him remanded yesterday. On the 24th of July, the day after he went to Canada, he was involved in an altercation with a detective who was a Wayne County Sheriff's detective. And there was a testimony taken at length on the 25th, a testimony from Sergeant Kenny, a former homicide officer, and Detective Brian White about a crime that took place on a porch of the defendant's sister's house, I believe, when the detective was there to serve process. And at that time, Judge Giles heard the ruling and said, I find that the testimony is credible, and the court has a copy of the transcript. And I believe something happened on that porch, but it's not for me to say whether another crime was committed, but I believe that this violates a condition of the defendant's bond.
That was on a bond or hearing. I mean, the testimony that was taken had to do with the bond issue and what occurred. It wasn't a preliminary examination or anything like that, right?
No,
just on the issue of the bond.
Just on the issue of bond.
All right, go ahead.
And Judge Giles' thinking on that was because Detective White was there to serve a subpoena for this case, he felt that he had jurisdiction to hear the issue because the defendant was interfering with the service of process. And so he felt that that applied to this case. So at the conclusion of that hearing, he made findings that the defendant violated his bond. Did he remand him then? No. Did he order a tether? No. Did he put him in jail for a week? No. He changed the conditions of bond. And he said that you have to have drug testing, you have to have a bond now, you have to post some money, and then further restricted his travel to require any future travel to be required to be shown or motioned up, and the court has to approve it. No more notification, no more automatic, I'm going on business, here you go, here's a notification. They were required, he was required to ask the court's permission, just like any other defendant would have had. And let's keep in mind, he the defendant, had very liberal travel restrictions simply because of the job that he had. And we weren't complaining about that because we understand that the nature of the business, he may have to go travel. So we acquiesced to that early on, allowing him the very, very minimal requirements to give notification. But in that courtroom, on the 25th, 2 days after he went to Canada, there is the defendant. He's there. He knows that he went to Canada. He knows that he didn't give notification to the court to go on the 23rd, and he doesn't say anything about it. He doesn't say anything. It's not brought to the court's attention. So when counsel argues it's just about a trip that he had to make on counsel business and that mitigates the factors, well, sure, if it's business related and if it was an emergency, and I submit to the court and...
Is there any indication in the record anywhere, Judge Giles, that the defense team, anybody on the defense team knew about him going?
That's not clear.
Okay, move on. Okay.
A couple different things are said, but the defendant represents on the record that there was an emergency that he had to go to on the 23rd, and if this were a de novo hearing, we would talk about that issue. I believe there's evidence to the contrary, but for the purpose of this hearing, we'll go forward as abuse of discretion. The issue is, why didn't he tell anyone? He's there in court on Friday, and he didn't say anything. As the court correctly said, he's a member of the bar. He's an attorney himself. He's the mayor of a large metropolitan city. He knows what the bond requirements are. He professes to the court yesterday to take this case more seriously than anything else he does, and yet he sits quietly by and ignores telling the court that he violated the bond. And yeah, we didn't know about it. We didn't know about it until the 28th when the news story broke. At least the prosecutor didn't know about it. So it's not just him going to Canada on an emergency situation, which we contend isn't true, but I'll move on. It's about him not telling anyone and misleading the court and trying to get away with it. So then, those are the factors that the court was considered yesterday. And the court heard our arguments. The court heard the defense argument. The court allowed the defendant to speak. the court took a recess. And the court came back and very reasonably said, you know, I've thought about this, and I have to treat him the same way I treat everyone else. And if this were anyone else, I would violate his bond. I would remand him. Not because he went to Canada, but because this is the third time we're here talking about a bond violation. Also because he's never told anyone about it. Also because he thought he got away with it. And no one would know about it. So I guess when the court considers the standard of abuse of discretion, the court has to say, did the judge below abuse his discretion in considering all those factors? I submit to you, Judge Giles did not, because he listened to the arguments, he heard the defendant out, and made a decision not from passion, not from bias or prejudice, but based on everything that was available to him at the time. He heard all that.
What of Mr. Parkman's argument or statement that the abuse or some abuse may lie in the nature and intent of MCR 6.106 to favor bond, or some stringent condition in that for a remand only, that there be some more onerous circumstances to justify a remand per se? That was part of his argument, you know, there, rather than some kind of bond, was there an abuse in making a remand rather than some other decision that would be more consistent with the intent of MCR 6.106?
Yes, sir. I think he was talking about MCR 6.106, and he's also using language from the Michigan Constitution about who was entitled to a bond. And Article 1, Section 16, talks about bail. But Section 15 talks about a person who was indicted for or arranged on a warrant charging murder or treason or other violent felonies. So it defines from the beginning, the Michigan Constitution defines that when you're arraigned on that information, based on the nature of the charge, determines whether you're entitled to a bond. He was done that. He had that opportunity. He was arraigned on the warrant. He was given a personal bond. That bond was later revoked, and he had to post 10%. And then he violated that condition of bond. So the question is, does that fly in the face of the Constitution of the state of Michigan? Well, he had his opportunity, and Judge Giles revoked that bond and remanded him because he did have a bond under the Constitution, but he, the defendant, is the one who violated the conditions of the bond. And what Judge Giles did was based on his observations. I would say it's not abuse of discretion, but a means by which to control someone who's on bond.
I'm not sure I understood your response to my question. You are saying that under these circumstances, even though this is a remand, and there are certain circumstances where remand, is justified and recognized by these statutes or by the rules, that the aggregate or the circumstances here justifies the remand in spite of what MCR 6106 says about that. Is that the essence of it?
It is. I think the difference I was trying to suggest, Your Honor, is that there's a difference between having a right to a bond, which is, I think, the Constitution and the statutes say that unless you're charged with murder or treason, you have a right to a bond. And the defendant had that right.